MCR Oil Tools versus United States Department of Transportation. Ms. Rusconi.
Thank you, Your Honor. May it please the court. For over 30 years, MCR Oil Tools has consistently shipped its proprietary thermite mix in disassembled components of its radial cutting torch without a single safety incident, and it did so with the blessing of PHMSA's predecessor agency. Yet in May of this year, PHMSA issued a decision barring transportation of that exact same shipping configuration, suddenly exposing MCR to civil and criminal penalties if it shipped the RCT as it always had. PHMSA did not do so because it found MCR's thermite mix to be too dangerous for transportation. Just 2 years earlier, PHMSA classified the mix as a flammable solid and approved it for transportation. Instead, PHMSA concluded that shipping the already approved mix inside shrink-wrapped steel containers created a new explosive and required its own separate approval. But as this court has already recognized, that business-altering decision was wrong on both the law and the facts. The decision ignores the requirement that to be a new explosive under PHMSA's own regulations, there must be a change to B15 itself. And even if changing B15's packaging were enough, the studies and test results before PHMSA plainly contradicted the agency's conclusion that such a change altered B15's properties. PHMSA's decision was thus arbitrary and capricious and should be vacated. If the court has no questions, I'd like to start by just making 3 points. The first is that...
Does any aspect of your argument require us to reject or find invalid PHMSA's interim thermite policy?
No, Your Honor, I do not think it does. Just by looking at the text of 49 CFR 17356A2, the question before the court is just whether this is a new explosive, whether there's been a change to the mix so as to alter the mix's properties. There's no need to get into the applicability of the interim thermite policy in our view. And Your Honor, as this court has already recognized, PHMSA's decision fails for the exact same reason Your Honor said on just page 7 of your stay opinion. The plain text of 17356A2 requires that there be a change to the formulation, design, or process of B15 specifically. Nothing in the record suggests that MCR changed B15. It's still composed of aluminum and iron oxide. It's still in the same pressed pellet form. MCR hasn't changed the process of how it's manufactured B15. And PHMSA itself has actually repeatedly recognized that the mix that is in the disassembled RCT components is the same mix that PHMSA itself approved as a flammable solid. And the government really offers no response to this. The only thing the government points to is that by confining B15 in the disassembled components, that changes B15's design, but that's not how we normally think of changing the design of a substance. I mean, that would be changing, again, maybe if MCR had changed whether the mix was in pellet form or loose thermite, that would be a change to the design. But a change to packaging, again, as this court already recognized on page 7, that's an external change. That's not a change to the substance itself. And so for that reason alone, this court can vacate PHMSA's decision. But there's also a more fundamental problem here. There are serious questions as to whether 17356 generally applies to B15. As MCR has repeatedly pointed out, PHMSA reclassified B15 from an explosive to a flammable solid. And the definition of explosive at 17350 of the Code of Federal Regulations excludes from an explosive a substance that has been otherwise classed. That is exactly what happened here. If you look at page A8 of the appendix, that is what shows that PHMSA has reclassified B15 as a flammable solid. That is what it was classified under 17356, and therefore it's not an explosive. And so there are, again, substantial questions as to whether 17356 could apply at all. And even if your honors accepted PHMSA's reading of 173.56A2, the decision is still arbitrary and capricious. PHMSA's new explosive finding rests on the fear that confining B15 in RCT components could cause rocketing or grenading and thus hinder firefighting efforts. But Your Honors, I think even if we just broke those findings down piece by piece, I mean, first of all, PHMSA doesn't cite to anything to support those conclusions. As this court recognized, such conclusory assertions are enough to find the decision arbitrary and capricious. But even if you then look at the record, it becomes clear that not only are they unsupported, they're flatly contradicted. I mean, just take, again, just one by one. Their first conclusion is that by confining the RCT, or confining B15 within the RCT, that could produce a focused stream of plasma that is forceful enough to operate at pressures of 10,000 psi. But if you actually look just a few paragraphs down in PHMSA's own decision, they recognize that that's how the RCT is meant to function when it's fully assembled. But that's not how MCR ships the RCT. It ships disassembled. And record evidence after record evidence shows that those different disassembled components cannot function as designed. If you look at A318, if you look at A324, A325, they all repeatedly tell PHMSA, we've repeatedly told PHMSA, these components cannot function. They cannot produce this stream of plasma that you are afraid of. And yet that's exactly what PHMSA said they feared would happen. PHMSA also said that they expected the sections of the RCT to confine the B15 mixture in a way that would cause rocketing or grenading. But again, piece by piece of evidence flatly contradicts that. You can look at their own description of UN Series 2 testing, which we conducted on B15. That's why B15 was classified as a flammable solid in the first place. And PHMSA itself said that Series 2 is designed to test the sensitivity to shock and the effect of heating or ignition under confinement. That's at A13. That's PHMSA's own description of why it classified B15 as a flammable solid, because it passed a test meant to look at confinement. PHMSA's own research studies confirmed that confinement does not appear to increase the burn rate of thermites, rather it appears to contain and suppress the explosion. And then that's not even considering Series 6C test, which PHMSA itself pointed out that is the basis for forming their concerns about confinement. You use the Series 6 testing, and yet there was no recognition that MCR conducted those tests and passed those tests repeatedly with flying colors. In the end, Your Honors, PHMSA's conclusions here were, in your own words, so implausible that it could not be ascribed to a difference in view or the product of agency expertise. For that reason, the agency's decision should be vacated. I reserve the remainder of my time.
Yes, you've saved time for rebuttal, Ms. Rusconi. Thank you. Mr. Ross?
Thank you, Your Honor. Casen Ross for the United States.
So what do you do with this point that Ms. Rusconi made that the B-15 is shipped in a disassembled state such that, according to her, it can't explode?
So the agency concluded that because the explosive substance was packaged in a particular way, it constituted a new explosive that was an article. And in this way, this is where the text of 173.50 comes in, where it defines an explosive to include both a substance, that is the B-15 mix, or an article, that is the explosive substance put in another item. Think of a grenade, for example. The explosive substance inside of the grenade is an explosive in itself, but the grenade, as an article, is also an explosive. And those are regulated differently, because I think you can imagine that the explosive substance within the grenade is going to react differently than when the grenade itself explodes, similar, for example, to a pipe bomb or to a firework. So the agency reasonably concluded that when you put the B-15 mix in the torch components, they could produce rocketing and grenading effects, as in fact the torch is designed to do. And that was based on, as the state decision recognized, MCR CEO's own testimony to the agency. That is, based on his representations, excuse me, getting over a bit of a cold, the explosive would react in a different way than if it were shipped separately. And I don't believe it's disputed for purposes of this case that if the B-15 mix was unconfined, it would just burn in place. But if you put it in the tubing for the torches, it would create a stream-like effect, which is in fact designed to cut any oil well. And it's true that the B-15 mix will not operate exactly the same way as when it's fully functional. But again, taking my firework example, say you remove the fuse from a firework. The firework is not necessarily going to react in the same way as if it has the fuse attached to it, but there's still the explosive potential when it's being shipped in that particular configuration. And that was exactly what the agency concluded here, that by changing that configuration, there was a different kind of explosive risk. And those are the kinds of factual determinations that the Supreme Court's Florida Power and Light decision and this court's Huawei Technologies decision are best left to the agency's expertise. And those kinds of factual determinations were reached based on the company's own representations to the agency itself. I do actually want to take a step back for it, however, and address the court's jurisdiction. Because this was a premature decision, MCR's petition was prematurely filed. The decision at issue here is by the Deputy Associate Administrator for the agency. But Congress specifically provided in 49 U.S.C. 5127 that only a final action by the Secretary is reviewable exclusively in the courts of appeals. Now,
But the order under review did say that it was final.
so of course, Judge Smith, it's final for purposes of reaching a decision at this juncture, but the agency's regulations specifically define what constitutes a final action by the Secretary as the final administrative decision by PHMSA's administrator. And that's an important distinction from, for example, the Administrative Procedure Act.
But insofar as MCR is concerned, it's enforceable at this point?
So, in fact, Your Honor,
Enforceable, it sounds pretty final if I'm subject to the enforcement.
so you're right, the letter itself does come with legal consequences. However, that was equally true on May 9th. That is, this explosive configuration, the explosive article, was not approved for transportation on May 9th, just as it was not on May 10th. So it is true that the letter itself creates legal consequences, but MCR could have been subject to enforcement penalties even before the agency issued the decision here. And that this kind of robust and considered decision-making that the agency's regulations contemplate, that is, first seeking reconsideration and then an appeal to the PHMSA administrator, is an important part of administrative law. In fact, I think the Chenery Doctrine is reliant upon the fact that the agencies are required to elaborately articulate their reasoning for reaching a particular decision, and in fact, when those decisions are challenged, the government cannot rely on any explanation not in the agency's own decision. And I think actually turning to the B-15 mixed decisions, referenced at A7 and A8, underscores why that's important for this particular circumstance, in that those initial decisions are a single page and simply confirm that the B-15 mix, exclusively when shipped as a substance, could be shipped according to the Class 4 flammable substances regulations. But those are only a page long, and so MCR, as the regulations contemplate, sought further review from both the Associate Administrator for hazmat or hazardous materials, as well as PHMSA's administrator. And they have also challenged that decision in this court and put that case in abeyance pending a decision here. But that only goes to show that the subsequent decisions by both the Associate Administrator and PHMSA's administrator lay out the basis for the agency's thinking that provides additional basis for this court to review that explanation. So it is true that the May 10th decision is final in some sense, but it is not the final action by the Secretary for purposes of this court's jurisdiction. And again, that's an important jurisdictional distinction, that Congress determined that only certain decisions should be reviewable upon reasoned consideration before the agency. And I think that's additionally confirmed by just background principles of finality under the APA, where courts regularly look to the agency's regulations to determine whether there is, in fact, a final action. And all of those decisions confirm the same result here. This is an interlocutory interim decision that it would be subject to further review within the agency. MCR just simply did not avail itself of those proceedings. So, absent additional questions on...
In the meantime, they wouldn't be able to ship this product, right?
That is true, Your Honor, but that, again, was also true on May 9th, that the product was not approved for shipping as an explosive article on May 9th any more than it was on May 10th. So it is something of a mischaracterization to say that the May 10th decision barred MCR from shipping its product. Rather, it confirmed the existing state of affairs that MCR could ship its B15 mix as an explosive substance, but it could not ship it when packaged in the torch components. I would like to address the important distinction with the UN testing that is in the record. So the UN Series 2 testing is only for explosive substances and only would have confirmed the B15's ability to be reclassified for limited purposes as a Class 4 flammable substance. But as the agency's decision on that score makes clear, it would not provide approval to ship the explosive in the torch components as an article. And in an effort to get in front of MCR's anticipated request on that score, the agency repeatedly explained that you just need to provide studies confirming how the article should be shipped and classified, and under those circumstances, the agency must give the approval. There's actually no discretion in this respect, that if MCR had provided the requisite studies to confirm how the explosive article should be classified and shipped, the agency would have approved it for doing so. And this is where the UN Series 6 testing comes in, which is it only would have demonstrated that the explosive article performed in certain ways, but it did not clarify what the explosive risk was. And again, that's important, and that's what the regulations reflect, that the agency is operating on recommendations from independent, trusted laboratories to be able to determine how explosives should be classified and shipped. And there are a number of different kinds of Class 1 explosives that are treated differently according to their explosive risk. So 173.56b specifically contemplates that regulated entities will provide clarity on the explosive risks that their articles present so that they can be shipped safely. And those are the kinds of judgments that Congress has vested with the agency to ensure that these articles are shipped safely. Now, that MCR repeatedly points to the fact that it's operated safely for a number of years, and that's all well and good, but the agency's responsibility is to mitigate those risks. And it's up to them to determine how to most safely guarantee shipping of explosives, bombs, in commerce. And those are the kinds of decisions best left to the agency's expertise, which was fully explained in this particular decision. Absent additional questions, we urge the court to deny the petition for lack of jurisdiction or deny it as a matter of law. Thank you.
All right. Thank you, Mr. Ross. Ms. Rusconi for rebuttal.
Thank you, Your Honor. May it please the court. The government's arguments, both as to finality and to the merits, really come down to a misunderstanding about what the decision was before the agency. The question was not whether MCR's shipping configuration should be approved. The question was whether approval at all was required and whether B15 in the disassembled components was in fact a new explosive. As to finality, this court has already rejected the government's arguments. In Darby, the Supreme Court made clear that finality comes down to whether there is a decision by the initial decision maker that is definitive and is one that causes immediate concrete harm. That's exactly what we have here. The government itself admits that the decision had legal consequences, that MCR could be subject to not just civil, but criminal penalties had it shipped the RCT in its disassembled state, as it always had. And the government keeps saying that this is not any sort of new legal consequences because that this was always true because it was not shipped, was not approved. But again, that just comes down to whether or not approval was required in the first place. Because we have maintained that approval was not required, because the shipping configuration did not create a new explosive, by saying that it was unapproved and that it did need approval, and saying that it shall not be shipped or offered for transportation, which is what the agency said at the last page of its decision, that was a final decision from which legal consequences flowed. It was immediate. And Your Honor, the government is wrong when it says that B-15, if ignited in the disassembled components, could create a stream of plasma. Again, as I said before, the disassembled components are designed to create that stream of plasma, but when disassembled, they cannot. Just to explain for a moment, the RCT, when fully assembled, there are 3 different pieces of it that have the B-15 mix in it. When it's connected to a power line on an oil rig, that ignites, that heats up a coil that then ignites the thermite in one of the pieces. When that thermite is ignited, it builds pressure that goes from one component to the other. That pressure has to build throughout the entire tool, the entire assembled tool. If that pressure doesn't build when it's all put together, then the nozzle cannot open, this plasma cannot come out. Honestly, Your Honor, if B-15 were ignited in the disassembled components, it would just burn in place and just go out very quickly, similar to a candle wick. That's all that would happen. And again, test after test shows that there are no safety concerns, no risk of firefighting hazards if that ignition were to happen in transportation. Your Honors, the agency's decision conflicted with both its own regulations and the record evidence before it. This court should vacate it. Thank you.
All right, thank you, Ms. Rusconi. Your case is under submission, and the court is in recess until 9 o'clock tomorrow.